Welcome everyone to the Judiciary Committee this Friday morning at 9:30. We have three agendas today. The first one's a 9:30 agenda, which is two judges for confirmation, and then we have two bills after that to hear. And then at 10:30 we have a joint decision making with consumer protection, and then at 10:35 we have a decision making on GM 596, which is the Attorney General's vote. If you're joining us on Zoom, we do have you'll be muted and picture taken away until it's your turn to testify, and then we do have a 2-minute time limit on testimony. If we have a catastrophic technical failure, we will reconvene on Tuesday, April 5 at 9:25 a.m. in this room and on video conference. And for the judges, we will not be voting on you today. We will be voting on your nominations on Wednesday, April 6 at 9:30 in this room. Okay, so first up on the agenda this morning is Judiciary Communication number 23. This is submitting for consideration and confirmation of the District Court of the First Circuit Judicial nominee Shelley K. Hawai'i for a term to expire in 6 years. First testifier on JC 23 is Barbara Creed. Written testimony and strong support. Thank you. Next is Lisa Bale. Okay, testimony and strong support. Thank you. Leighton Hara for Ota and Hara in support. And then a whole bunch of individuals in support, about, I don't know, 40, maybe 35, 40, something like that. Nobody in opposition. And then that brings us to Rhonda Griswold, President-elect for the Hawaii State Bar Association. Oh, on Zoom, sorry. Good morning.
Good morning, Chairman Rhodes and the Senate Committee on the Judiciary. I'm here as President-elect of the Hawaii State Bar Association. We stand on our written testimony, which found Ms. Park Ho'opili to be qualified, but I am available to answer any questions that the committee may have about the HSBA's evaluation procedures. Thank you.
Thank you very much. Thanks for being here. And that's all the testimony we have on JC 23. Members, any questions for the testifiers who are here? Okay, seeing none. Ms. Park Ho'opili, if you'd like to come up and start to make an opening statement, you're more than welcome.
Good morning, Chair Rhodes, Vice Chair Kyo.
Can you hold the mic closer and talk louder?
Sorry.
Sorry, we have all these. Anyway, go ahead.
Is this better?
A little, yes.
Good morning, Chair Rhodes, Vice Chair Kyoho Kalole, and members of the committee. Thank you for the opportunity to appear before you today, and thank you so much for taking the time out of your busy schedules or over the past 2 weeks to meet with me. It was truly an honor. Growing up in Hilo, I lived a very simple, down-to-earth life, raised with great values and wonderful memories. We were not wealthy or even middle class, but I had the best childhood, rich with memories. My sister, brother, and I attended public school, participated in a lot of community activities, especially sports. We just had a great, happy life with great values about hard work, about dedication, and about commitment to doing the right thing. My parents always told us to work hard, to dream big, and to always give back to the community. No matter the trials and tribulations, for everything is a learning experience. And I was always told by my parents to be better. And being better meant not giving up when we couldn't afford college. Fortunately, I was able to attend the University of Hawaii at Manoa, and then the William S.
I'm sorry, I apologize. Part of the problem is we have this blower between us. Can you just pull the mic almost up to your mask? If it'll come that far.
That's better.
Yeah, that's better.
Oh, okay, sorry. But being better meant not giving up when we couldn't afford college. Fortunately, I was able to attend the William S. Richardson School of Law as well as the University of Hawaii at Manoa. But to do so, I had to work 3 jobs, oftentimes catching the bus from the university to downtown to work, then back to the university for classes, and then my job at the school library. But being better was just constantly making a difference in a positive way, taking on volunteer opportunities, joining community and national boards, and taking on leadership roles. Being better was always rising above a challenge. I grew up learning that sometimes you fall, but it's what you do after you fall that truly matters. I never imagined that I would go to law school. Growing up, that was a dream, maybe something in my imagination. I loved reading crime books, and I loved learning about the legal process, but never in my wildest dreams would I think that that would be possible. But then when I was nearing my second year of college, when I thought I was going to be a teacher, I was asked the question, what is something you want to do but never thought you could? I said, be a lawyer. And then the response was, so then why don't you try? And so I challenged myself. I figured to do that, I needed to know how laws are made. So I volunteered with Representative Jerry Chang from the Big Island. And I learned about the legislative process. I worked with him until I graduated from law school. Upon graduating from law school, I clerked at the Hawaii Supreme Court for the Honorable Paula Nakayama, where I researched and drafted opinions on complex legal issues, many of which were first impression in Hawaii. I then went to work at Alston Hunt Floyd & Ing, now Denton's, and had the best, most high-level litigation experience working with many of the top lawyers. At the firm, I was fearless. I wanted to learn everything I could about the law and all areas of practice. I took on tasks and cases that would challenge me, get me into the courtroom, make me think outside the box, and just make me a better person. As my litigation experience progressed and my desire to learn grew, I joined the firm's government affairs division, where I did some lobbying, prepared legislative testimony, and attended hearings. And then I have had the great privilege of being a staff attorney at the Supreme Court, where I went from being courtside and in the courtroom as an advocate to now being a neutral arbiter of cases, much like a judge. For the past 10 years, I have had this unique privilege, and importantly, a unique perspective and insight that I could share if I'm confirmed as a judge. In an impartial and objective manner, I have had to review and consider both sides of arguments, evaluate the law, and then make a sound, reasonable recommendation on the disposition of matters to the 5 justices. During my tenure, I have worked on a breadth of practice areas covering a wide spectrum of the law, criminal and evidentiary issues, civil issues, constitutional issues, family law issues, administrative issues, and so forth. I've also worked on court rules and legislative matters. And I've had to balance my workload to ensure timely disposition of cases and matters that come before the court. I have embraced this wealth of experience that very, very few people have, which has prepared me for a judicial position and allows me to bring a different and perhaps a diverse perspective to a judicial role. Through this unique experience, I have become comfortable in being able to discern issues, oftentimes being sympathetic to cases that requires the court to step in to allow the pursuit of justice to be meaningful. These are moments that are truly rewarding, to be able to help someone. That's all I've ever wanted to do, help people while making a difference. And therefore, something that I'm most proud of is serving the community. I've been able to do that with my roles on various local and national boards and in leadership roles, such as being president of Hawaii Women Lawyers and now current president of the Hawaii Women's Legal Foundation. I took on those roles not only because their missions are truly an extension of my heart, but really because I often shied away from public speaking. And so it forces me to challenge myself and continue challenging myself, but also to show my daughter, who is here today, that it's okay to be scared of something, because it's what you do with that fear that helps define you as a person. So as I continue to grow and define myself, it was important for me to take on challenges that culminate with all the experience that I have. I am proud to have my background and know that it has prepared me for this next journey. Should I be confirmed as a judge, I know how to work hard and put in the time to be exemplary. I will be someone committed to continue the work of many others to make Hawaii a better place. I promise to continue working hard, continue committing myself to doing the right thing, and to continue to always be better. I am sympathetic and compassionate, yet firm and willing to make tough decisions. I'm also a people person, and I'm able to relate to all individuals. I'm comfortable multitasking making decisions and working under pressure. And at the end of the day, I'm just a simple local girl from very humble upbringing who understands life's struggles and recognizes the suffering some people may be going through, and who just hopes to be better and make a difference wherever I go. Thank you for your time, and I'm available for any questions.
Thank you very much. Members, questions? Well, I'll start if no one else wants to. So as a district court judge, you're probably going to be seeing in many, occasionally anyway, you'll be seeing individuals who, once they've been convicted of whatever it is that they've been charged with, you'll be looking at their pre-sentencing report and seeing that they may have 10, 15, 20 prior convictions of similar offenses. I think it's fair to say that people are really sick of what they view as criminals who just get back out on the street 3 days after they've done whatever they've done. What's your philosophy going to be on those who on defendants where you have to? I understand as a judge you have to take each case by case, and you have to convict or not convict based on the information in front of you. But once you get to the sentencing stage, that's a different story.
Mm-hmm.
What's your general philosophy on people who have committed multiple offenses or have been convicted of multiple offenses when you would get to a sentencing decision there?
Thank you, Senator Rose. I think like you recognize, it's never a one size fits all situation, and you look at everything case by case. You look at the situations, you look at the laws that are before you, look at the statutes, you look at their history, and you make an evaluation based on that. Sometimes I think a really big issue that comes up is sometimes there are societal or systemic factors that play into why we're seeing individuals that come repeatedly before the courts, and that sometimes there are situations that you may need to help them. So I think it would just be something important that you look at everything that's before you, you look at their history, you look at their background, and you see how you can make the best decision for them.
Would you hesitate to give somebody a maximum sentence if you felt like they deserved it, if the facts?
Would I hesitate to give them
a maximum sentence if you felt like the facts warranted it?
I would not hesitate to give a maximum sentence if the facts warranted that.
Okay. Okay, I have other questions, but members, others. Senator Kim, go ahead.
Thank you. Good morning. Thank you very much for your opening remarks. How do you feel about restitution? We hear a lot from the public and from attorneys and public defender and the prosecutor, and that judges don't often or don't like to give restitution for some reason. What's your thoughts about restitution?
I think, like I mentioned before, I think everything is a case by case. I think restitution is an important mechanism that sometimes brings about the justice that needs to be seen. I think without having looked at a specific situation or circumstance, I think it would be something important as part of a sentence to require restitution if that's something that's needed. So it would be something that I would look at.
You wouldn't hesitate.
I would not.
To utilize restitution and community service together, or
In combinations like that, yes, I think that those are very important.
We also hear when we have these bills that want to increase the penalties for certain crimes committed or certain kinds of infractions. And then we hear on one side to say, well, raising these fines is not necessarily prevent people from doing it.
Mhm.
But if that's so, then why do we even have the fines to begin with? So I don't know, what's your sense as to, because we want to move away from incarcerating people. So what other incentives or disincentives are there if it's not going to be restitution or penalty, fines, monetary?
That's a really good question. I think those are all good tools, but at the same time, when you look at the whole incarceration, I think sometimes you have to look at the situation that's before you, and sometimes there might be alternative programs or treatments or mechanism with which to help people so that they don't end up back before you and facing the same situations that they are. So I think that's a really, really good question regarding raising the fines, because sometimes I think you might give a person a fine that they might not be able to pay. you know, and they're going to
Can you
end up
speak
back.
up a
I'm
little
sorry.
bit?
Sorry, you might
Just
give
pull the
them.
mic closer, just put it
It's-
right
I
up.
think it's in the
Oh, is it
front. It's
stuck? I'm
tucked
sorry.
to
Oh,
the-
sorry.
No, it's stuck to the
Yeah, it's stuck to the-
plexiglass.
I can, maybe I'll scoot forward. Would that be better?
Okay. It's the mask, it's that machine. It's tied.
It's not up here. Here, it's pretty stuff.
All right.
I'll just
Okay.
lean forward. and
Thank you.
talk.
You just need to talk right at.
I'm
the
sorry,
mic.
I'll just
Yeah.
lean in here and talk.
But you hear a lot about repeated offenders.
Mhm.
And I think that's what really gets the public upset about repeated offenders or people that are out there preying on the elderly. And so, you know, we don't, and I know there's efforts to do away with bail. We don't want to incarcerate. We don't want to give restitution. We don't want to raise the fines. I'm not sure. You know, any thoughts on?
You know, I think just the current way that things are right now, I think I would have to follow what the law is and what the statutes are that are in place and what penalties are in place now. But I think it's always, there's always opportunities to improve. And that's something that's important to me, to make sure that we look at ways to improve and that you continue to have dialogues with stakeholders and people in the community that can voice their concerns or their perspectives and how you can make things better. And I think that's always important.
Okay, because you are the one between the victim and the perpetrator. And it is, you know, it's basically in your hands on how this is dealt with. So that's an important factor. So I think you'll keep that.
Thank you, Senator.
Thank you. Members, other questions? Senator Keogh.
Thank you, Ms. Parkwapili. You know, to follow on to that, I agree. In many of these individual cases that you will likely see before you, you'll see individuals who have long records of multiple offenses, and especially from the public and the victim's standpoint, a trend of systemic inaccountability to those individual actions. And so you pointed to the fact that there, within your discretion and within the judicial system, there is some flexibility to figure out how to address those problems. But I also am interested in your feeling on the broader systemic issues that we have before us, like the fact that Hawaii ranks at the top of the nation, and the nation ranks by far at the top of the world in terms of the rate of individuals who are incarcerated, the amount of individuals who are incarcerated who are poor, and the number of those poor incarcerated individuals who are suffering from some type of traumatic event, often that occurred when they were youth. So, you know, you spoke to the flexibility just now, and I'm wondering where you go with that, given the fact that from my perspective, everything that I said and that Senator Kim just said are all true. And the public is dissatisfied with the situation. I think it's fair to say all the way around.
Thank you, Senator. I think that's a great question. I think we had a really good discussion about contingency management and that being a feature. And, you know, that's something that I looked into, I started researching, and it really weighed on me having that discussion with you. And I think that's so important, because oftentimes when you step back and you look at this situation, you look at many of these individuals from when they were young children, they've had these challenges or that brought them up through this system. And so I think our discussion about contingency management was really eye-opening and great. And I think it's going to be an important tool moving forward.
So I appreciate that, but at the end of the day, like Senator Kim just said, you often have a victim on the other side who has had their rights, their property, or their personal safety violated by someone who seems to have been empowered by the system to operate with impunity. And there's a lot of frustration in the community when it comes to that. How do you balance the two?
I think, and that's one of the things that's big. It's that you have to do this careful balancing. And that's why sometimes when you think about programs, or you think about ways in which we can help these people, you have to bring in everyone from both sides so that you can see how these issues are impacting them. And we cannot forget the victims out there, you know? And so I think it would just be important to have these discussions.
Members, other questions? I do have one other one. So my first question had to do with the end of the trial that you would generally, in district court, it's generally a bench trial. I guess maybe it's
Bench
always a
trial.
bench trial.
Yes.
What about the beginning of the trial? If somebody comes in front of you and within, a couple of minutes, you realize that this person has a substance abuse problem, or even as a layperson, you're like, or they've got a mental illness, and what do you do? They've been charged with something, but I think in a lot of cases it's pretty obvious pretty quickly that they're not operating with in their full mental capacity. Well, what's your approach there?
I think that there is some mechanisms in place. We have certain, I think certain the assisted community treatment programs, or certain processes in place to address that. And right immediately at that moment when you believe that this person might be suffering from some type of mental condition that will not allow them to proceed with a trial or proceed with their case, you can go through this process and get them evaluated and see what the recommendations are from the treating physicians. And I think it has been happening through the court systems. And I was reading a report the other day about, oftentimes how much is being used. Sometimes, the struggle, I think, with district court with those types of programs is a defendant may be charged with a series of crimes, sometimes that don't fall within the confines of the statute that allows for them to get the type of treatment that they need. But there are these mechanisms that are in place to allow for that.
So I guess I'm assuming you're aware of, and I can't remember the act number. Anybody remember the act number for 2020?
I think it's 26.
26, Act 26.
Yeah.
That allows you to basically kick the person out of court if they're willing, or what we had hoped that it would mean is that you would say, okay, you can continue on with this trial if you want to, because you have been charged with whatever the offense is. But if you are willing to go do the treatment, we will, we'll back away from the criminal side of it. Is that something that you view as a useful tool?
I think it is. I think it is something that is very useful, and that within the confines of what it, the way it's.
And you mentioned that there's a lot of crimes that don't fall in there. So.
Yeah, I think within the district court context, they may be charged with all these other crimes that don't fall within it. But I do think it's a very useful tool, and I think it has been utilized in the district court, maybe not as frequently as the act had intended it to be used, but it has been utilized.
Yeah, so I just wanted to emphasize that, at least from my perspective, it was something that the idea was not to drop the charge before you assign them to the mental health treatment, because if you drop the charge, then they have no incentive to go with the mental health treatment.
Yeah.
So just a reminder of what I viewed was the legislative intent there. Members, any other questions? All right, if not, thank you very much. As I mentioned before, we will vote at the committee on your nomination on Wednesday, April 6th at 9:30 a.m. in this room.
Thank you so much.
Thanks for being here. Next up, we have Natasha R. Shaw for consideration confirmation to District Family Court of the First Circuit. And first up and that's JC Judicial Communication number 24. First up on JC 24 is Nellie Ann Shiroma. Okay, in support. Thank you. Nia Long. Yeah, sure, of course. I'm sorry. I didn't realize there was any question that yeah, come on up, please.
Good morning, Senators.
Good morning.
Thank you for allowing me to speak on behalf of my mom. I am the eldest daughter of the family court nominee, Natasha Rainey Shaw, and I am so proud to be standing here today advocating for someone who selflessly advocates for others and has always done so for me. My mother often boasts more about her children than she does herself, so let me take the time to return the favor. Something that I did not include in my written testimony, but would like to make note of now, is my mom's incredible skill for seamlessly balancing her passion for her family and for her work. I have many fond memories of my childhood, from playing board games with my mother to having long conversations about everything under the sun. Amongst all that she has accomplished professionally, my mother has never failed to give every minute of her time to being present with her children. The way she's able to compartmentalize and point her full attention to something that she's passionate about will serve her and our community right in the decisions that she will make as a family court judge. My mom has been my personal place of comfort and sadness, happiness in the ordinary, and inspiration amongst the downhearted. While I selfishly want to keep her to myself, I know that my mom can and will make an even greater positive impact on the lives who go through family court. Thank you again, Senators, for your time and consideration.
Thank you very much. Next, we have Jared Kawashima for Yi Kawashia LLP in support. Andrew Smith for Andrew Smith LLC in support. Gail Ching for Gail LF Ching LLC in support. Kelly Hawai'i, President, Korean American Bar Association in support. And Eric Taniguchi for Taniguchi and Associates in support. After that, we have about a page and a half of almost all supportive testifiers. There is one written testimony in opposition, Randy Wong. And that brings us to Rhonda Griswold, President-elect, Hawaii State Bar Association. If she's still here. Oh, there you are. Morning again.
Good morning again. We'll stand on our written testimony, which found that Natasha Shaw was qualified, but we're available if necessary to answer any questions that you may have about the Hawaii State Bar Association evaluation process. Thank you.
Great. Thank you very much. That's all the testifiers we have on JC 24. Members, any questions for any of these testifiers? Okay, seeing none, we're going to take a short recess and try to fix the mic. So tech support, we're going into recess just momentarily. Recess for the Judicial Committee. Judge Shaw, if you'd like to make an opening statement. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair Keohopolole, Senator Gabbard, Senator Lee, Senator Ocasio, Senator Kim. Thank you for the past 2 weeks that you've given me time, for sharing stories, and for your consideration. I'm truly humbled and grateful for the nomination by Chief Justice Rechtenwald to the First Circuit Family District Court. I'd also like to express my appreciation to the senators who are not on this committee, who also made time for me to get to know me a little better. Thank you. By way of background, I am the proud daughter of a United States Army Green Beret Special Forces retiree. He taught me hard work is key, to persevere, to never make excuses for anything, and to always be grateful, no matter what your circumstances are. I am also the proud daughter of a South Korean immigrant who is one of the most loving, courageous people I've ever met, who is also here today. I'm proud to be your daughter. My children are also here. My daughter, who just spoke on my behalf, my son, and my other daughter, who is also here. By way of background, I have come so far, given my personal circumstances in life. As I just shared, my parents taught me so many wonderful things, which is one of the many reasons why I want to be a family court judge. I have 2 siblings. My brother is one of my best friends. He's a great dad. He's a computer engineer, and he happens to be a world champion jiu-jitsu. My sister is one of my rocks. She's so full of love and joy. She's also a tough mom of 3 boys, and she's proud to be a nurse. As again, I just mentioned my children who are my world, my everything. My daughter is a mechanical engineer. She hopes to focus her career on using technology to give back to the environment. She's already created a drone that does that to collect water samples, and I'm so proud of her. She's also very humble and kind. My second daughter is an amazing, strong, compassionate, and kind individual who hopes to have a career in mental health and awareness. During the pandemic, when her school shut down, she was faced with a number of circumstances that really caused her to look inside. And as soon as school got back, she realized many of her peers were suffering in silence. So she created an organization to make mental awareness a topic to discuss so that you don't have to be shamed by it, and so that we can address how to help. My son is the most amazing son a mom could ever hope for. He's so loving and kind, supportive and caring. He still hugs me in public, and he loves all things baseball. And I appreciate all my kids very much. Up until I was about 7 or 8 years old, I had a very loving and stable upbringing. But my parents' divorce turned my world upside down. Given my mom's challenge with the English language, being in an unfamiliar country, she decided to put our best needs first instead of her emotional needs. And she allowed my father to have full physical and legal custody of us. I'm very grateful for my mom doing that. My dad did the best he could as a single dad, raising the 3 of us on his retirement pay. We were very poor growing up, so poor that we were homeless at a few times. Despite those challenging circumstances, my dad would force us at the time to give back to the community, to volunteer at shelters, care homes, so that we can see that our lives were not that bad. It could be much, much worse. Those moments provided us a moment of happiness. Just to give back, it's so easy, so simple. So my brother, sister, and I continue to give back in our community today, and will continue to do so throughout our lifetimes. The experiences that I faced during my childhood allowed me to be the person who I am, to understand that caring is so important to the passions that we want to see in our future. After high school, I attended college while working several jobs. I bussed tables at a Chinese restaurant. I worked retail at the Disney store. I worked for an accountant as a junior accountant. I eventually graduated. I earned an accounting degree, a JD MBA, with all that hard work, with earning scholarships and qualifying for Pell Grants. After graduating, I was privileged to have 10 years of experience in accounting and internal auditing and business management. But after earning my JD MBA, I decided to move home back to Hawaii. We were living in Florida at the time. The areas that I were living in, my first daughter, she was in kindergarten. She was the only Asian student in her entire elementary school. And reflecting back, when I was younger, a number of the places we lived on the mainland were not diverse. I was bullied, picked on, and beaten up at one point because I'm Asian. Experiencing discrimination at such a young age is heartbreaking, to say the least. I did not want my kids to experience this at such a young age, so I decided to move back home. I wanted them to grow up in an environment that would empower them, that would let them be free of mind, to dream limitless possibilities. I don't regret coming home. Moving back home for my kids was one of the best decisions I've made. I'm so proud of who they've grown to be, and I can't wait to see what amazing things they will do. After moving back home, I was fortunate to receive a clerkship in the probate court. I remained in the legal profession as an associate level civil litigation attorney, senior associate civil litigation attorney, serving as kokua kanawai in contested guardianship and conservatorship matters, as special master, special trustee, trust protector in highly contested estate, guardianship, litigation, trust and estate litigation matters. I'm a sole practitioner, and since 2019, which makes this my 4th year, I've been privileged and humbly serving our community as a per diem district family court judge, sitting in the special division, which involves guardianships, domestic abuse matters, involuntary hospitalizations, assisted community treatment, paternities, adoptions, and the domestic division involving divorce proceedings. Within a few months of being at family court and being so fortunate to work with some of the most amazing people I have ever met, I had found my purpose. My life experiences have allowed me to become a very courageous and compassionate individual who sincerely cares about others. My educational and professional backgrounds have further prepared me for family court, which demands a detailed analysis of the facts and circumstances in order to apply the law accordingly. My 4th year at family court, I've worked so hard with great enthusiasm, which still remains today and will carry on throughout my career, no matter how tiring it may be. With passion and faith, I believe I am making a positive difference. I am beyond grateful, incredibly honored to be nominated by Chief Justice Rechtenwald as a First Circuit District Family Court Judge. If I am fortunate to be confirmed by the Senate, I will continue to work hard from a place of service for our community and for our judiciary. I want to thank Chief Justice for nominating me to serve the family court. I'm very humble and sincerely appreciative. I'd also like to express my sincerest gratitude to the Judicial Selection Commission, Ms. Mao Shimuzu, Ms. Griswold, members of the Hawaii State Bar Board, Mr. Miley, Ms. Aluwag, to my mentors, colleagues, friends who are, many of them are here today, and to my family court ohana. I'm very humbled and very grateful for all of you. Thank you with all my heart and soul. And lastly, I want to thank my family, to my remarkable daughters, my amazing son, my resilient and courageous mother, who are present here today, and my family members who are not able to join us today, my brother, sister, nieces and nephew, and my family in South Korea and New Zealand. Thank you for everything you've done for me. And I know you are here with me in heart and spirit, especially my dad. Thank you, senators. I'd be happy to answer any questions.
Thank you very much. Members, questions? I have a question about the Assisted Community Treatment Act. I understand you've already done a case, at least one case, for one petition for an ACT since you've been sitting for diem. The question is, well, first question is, are there very many of them at this point that you're aware of? Very many ACT petitions filed?
There are. Yes, Senator.
Meaning how many? One a week, couple a week?
Well, it's designated calendar. It's on Thursdays,
Mhm.
and the chief family court judge is handling those calendars right now. But I don't know the number.
But you think there's a significant number of them at this point?
From my understand, well, I'm not sure what significant is, but there are a number of petitions that
Okay.
are going through the family court.
I think the one that you said that you had dealt with already, you had eventually denied the petition because the person was getting their medication from somebody else, and they seemed to be taking it, and everything was, well, things looked to be improving. Is that correct?
I had to deny the petition because it didn't meet the statutory requirements as required by law. So I denied it.
Okay. Was there Was there a happy ending to it, or was it just, that's it, it was denied? And
I don't think that was really the question at the time. I think because this particular individual wasn't, he didn't fall within the requirements of the first prong of that statute, which requires a proof beyond a reasonable doubt. There were those factors that he didn't fall within. And so that question regarding a happy ending of this particular situation, I don't think that was even an issue at that time.
okay, but you, for some reason, I thought that you had said that you knew that his service provider had found someone who he trusted enough to take the meds from.
Yes, and because he was complying, there was no danger.
I see. Okay. In terms of the law itself, though, I mean, if the petitioner proves the case, you don't have any trouble with ordering somebody to take their meds?
Yes, Senator, I have no problem.
And why is that? Do you think it's, I mean, why, I mean, there's certain how to phrase the question. There is obviously a liberty interest for an adult who is otherwise in their right mind. You can't tell them to take their meds, basically, as we've discovered over the course of the pandemic. But during but for someone who's mentally ill, you believe that liberty interest can be overcome by the need for medical treatment?
The statute provides for it, Senator. So if there is proof beyond a reasonable doubt that the individual is in fact mentally ill, that there is a great danger for himself and or for others, that particular prong overcomes the liberty that you're talking about. So
Okay.
Absolutely. And in addition to that particular statute, you need a psychiatrist to opine on all those things, and or a nurse practitioner who has a psychiatrist background and to be certified. So if the doctors are opining that this individual has a mental illness, is in fact dangerous to him or herself and or others in our community, and that is proven beyond a reasonable doubt, I have no issue with granting that petition.
How do you, what do you think is dangerous? Is dangerous if they're not treated, they're going to die on the street, or is dangerous mean they stab somebody?
Both could be applicable.
Okay. Members, other questions? Senator Kim, go ahead.
Good morning.
Good morning, Senator.
During our conversation that we had, we talked about our tough childhoods and how, we want to make it better for our children, and certainly we give them a lot more. And sometimes you see families where the children may not be as responsible, or certain issues which you probably will see, or you do see in the family court. How responsible do you think the parents should be held because we raised this generation and each generation prior to that, and so how much responsibility should the parents, in your opinion, and as a family court judge, would you place on the parents for the actions of their child?
Well, as a parent, I think it's very important to acknowledge and accept certain circumstances. It's critical for us to be actively involved, passionately, tirelessly, trying to support our kids as best we can. There are so many outside circumstances, external, out of our control as a parent. Kids that are faced with so many different pressures that make decisions that aren't in their best interest. And we see them in the system. They're suffering. The parents are suffering. Oftentimes in family court, we have the parents who are participating in the proceedings because we're hoping that these children are able to overcome. And we need the parent support. And oftentimes many of these kids don't have that support. It's heartbreaking. But to hold a parent accountable, it depends on the circumstance. I would have to really assess each case that comes before me to understand what, in fact, I would consider if I'm holding a parent accountable. I mean, if the parent had knowledge of certain things, if they're aware of potential circumstances, dangers, and didn't let somebody else know, that's a factor. But I wouldn't know until I would see every case.
In a recent crime that had been committed, was, and this was told to me, so I'm not sure how accurate I am, but that the father, been a police officer, had protected the son over the years so that he would not be held accountable for actions and so forth. And at the end of the day, he was a troubled child, and therefore there was, I guess it resulted in his death. But in a case, situation where I know parents try to protect the children, at some point, accountability, and again, as a family court judge, you will see these things, and I'm not sure how we resolve that, but that accountability and is certainly important in the whole community and the whole scheme of things. So
I would agree with you, Senator.
okay. Thank you.
Thank you. Members, any other questions? So it appears that you don't have a ton of criminal law experience. Is that fair to say?
That's fair to say.
So your primary interest here isn't, I mean, my understanding, this is for a family court position, so the criminal law is less important. But as you're aware, CJ can switch you over to district court if he chose to. Would you still want to serve if you were switched to district court?
My passion, my hope, my intent is to stay at family court if I'm confirmed. For as long as possible, it's where my heart and soul are. However, if CJ asks me to be assigned to another court because of the need, because he feels that I can help that area, help our community, I would likely, of course, respect CJ's consideration. However, my hope and intent is to stay at family court.
Okay. All right. Other questions, members? Okay, seeing none, thanks very much for being here. We, as I mentioned before, we'll be putting off the decision making till Wednesday, April 6th at 9:30 a.m. in this room. So
Thank you,
see then.
Senators.
Thank you. Let's go, members. Well, everyone, let's go ahead and move on to the next item on the agenda, which is HB 188. This is about electioneering communications. It increases the threshold amount that requires disclosure of electioneering communications and requires that disclosures occur on the date the electioneering communications are publicly distributed. First up on 1888 is Gary Camp for campaign spending.
Good morning, Chair, Vice Chair, members of the Judiciary Committee. The Campaign Spending Commission supports this bill as currently written. We ask that you put on a good effective date. Thank you.
Thank you. Next is Sandy Ma for Common Cause, Hawaii. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. Common Cause Hawaii supports HB 1888. We do ask that candidate committees be covered by the electioneering communications law and have to file statements of information. That's our only suggested amendment to this measure. I'm available to answer any questions. Thank you very much for hearing this bill. Thank you.
Thank you. That's it. All the testimony we have on it, or I should just, I'm not used to doing this anymore. Anyone here want to testify on HB 1888? Okay. Seeing none, members' questions. Mr. Cam, I have a question for you. You know, we've been going back and forth on this on requires that the disclosures of electioneering communications occur on the date the electioneering communications are publicly distributed. And I keep changing it back to when the forget my terminology, when the expenditure is made, I guess. The problem that I see, and of course this doesn't apply to candidate committees, but for a non-candidate committee, how do you know when the example is for small races like mine, you mailing is a big deal, and you tell your mail house to send the mail out at a certain date, but because it's going bulk rate, since it's going not first class generally, you don't really know when it's going to go out. You just know that it gets sent to the post office, and then sometime they send it out, and you don't, and then sometimes they don't even come to the same part of the district at the same time. So it might get to me 3 days after it got to somebody up the street. So I'm not sure if we put this in, how are you going to, what are you going to use as proof of publicly available?
Well, it would be when the, as far as a mailing, when it starts to hit people's mailbox, you know, the amendment doesn't say that you need to file these statements exactly 24 hours after it hits the mailbox, or, you know, it's just within 24 hours. And I think you can a committee can more or less guess when the mailers are going to reach mailboxes. I mean, I'm sure if they're using a printer to do it, you know, the printers put it out for mailing, right? And they can tell you when that's going to be. But we, you know, we're not looking for a 24-hour. You know, at the 24 hours, then it has to appear. It's anytime within that period. I'm
sorry, I guess it's 24 hours from when?
The ad is publicly distributed.
Right, but then what are you counting as publicly distributed? When it actually goes into the mail, or when it comes out of the mail?
No, when it gets dropped into people's mailboxes, or when the ad appears on TV or radio.
Yeah, I mean, the ads, the one for things like for TV and radio ads, that's easy enough. You know, you buy time for a certain specific point, but I just don't know how. I mean, I'm generally not all that sympathetic towards non-candidate committees, but I don't know how they're going to do that. I think you could probably ding most of them every time they mailed something, because they don't know when it's going to be in the mailbox.
Yeah, I guess I'm not. I don't know. I guess because people have been mailing these postcard advertisements, I'm not sure I buy that you don't exactly know when it's going to appear in people's mailboxes. I think that's the whole purpose of doing advertising, right? You have a certain target that you want the advertisements to reach your constituents.
Okay, well,
I do.
Go ahead. Sorry.
Okay, you know, this is at the federal rules level. This is how the FEC also does their electioneering communications. So, I've heard concerns from, well, maybe not from the senators, but from the representatives on how they didn't like to telegraph their strategies by having to make these statements when the expenditures are made or contracted for. So, you know, part of this type of amendment for setting the disclosure date when the ads run was to address that concern also.
Well, okay, so anecdotally, my campaign has a mailing schedule, and it's happened more than once in my career where the mailer that we thought it was going to hit between Tuesday and Friday of this week, and then we had another one for the next week that was supposed to hit between Tuesday and Friday. The second one got to the mailboxes before the first one did, and you know, there's just no way to know. So I'm going to put in some language, or I'm going to suggest some language that says, you know, when it arrives at a mail, for mailers in particular, when it arrives at a mailbox, or when they should have known that it arrived in the mailbox. But I just don't see any way to do that part of it with any exactness.
That's fine. I mean, I think the main goal of the commission is that what happened in 2021 is that the 11-341 was changed so that these non-candidate committees would only have to file one electioneering communication statement once the threshold is reached, and then thereafter they didn't have to file anymore.
Yeah.
So, you know, I think that's the main problem that we're trying to.
Okay, understood. Sure,
I just want to follow up on that. Having mailed stuff for the past 40 years, of which I've been in, I don't know how many elections, I still cannot predict when my mail is going to land in the mailbox. And as Senator Rhodes said, sometimes you'll try to space it out and they all end up on the same day getting into the mailbox. Since COVID, it's been worse. I've had mail to the neighbor island not get there for 2 weeks. You cannot predict. I've had people send me stuff that they said, you didn't get it yet. I didn't get it for over a week. And that's first class mail. So when we do bulk mail, which I do twice a year, we have difficulty in predicting, even though we use a mail house, even though we've done it every year, twice a year, the same thing, it's unpredictable and it's worse now. So I'm not sure how you base, what your response is to Senator Rhodes, but please keep that in mind.
I don't mail out ads. I'm not a candidate. So if this is in fact an impossibility, of course, it shouldn't be passed the way it is and go back to the when the expenditures are made or contracted for. That has been with us for years.
I just think we need a better dates because there's always this unintended consequences. Yeah. So
I mean, we don't want to set up a situation where all we have are violations. I mean, that's not going to work, right? It's better to have the disclosure than the violation, actually.
Yeah. Okay.
Thank you.
Members, any other questions on this one? If not, I'm going to take a short recess before we go to, we have a joint meeting with CPN, and I believe they're coming down here, right? So short recess.
Good morning, everyone. Welcome to the 10:30 joint committee hearing between the Committees on Commerce and Consumer Protection and the Committee on Judiciary. We have one item on our joint agenda, and it is House Bill 1823, House Draft 2, Senate Draft 1, relating to health. This is a Kapuna Caucus package bill and authorizes advanced practice registered nurses and physicians assistants to practice medical aid in dying or provide counseling to a qualified patient. Requires a prescribing provider to conduct an initial visit in person. Amends the mandatory waiting period between oral requests and provision of a prescription. Prohibits the disclosure, discovery, or compel production of information collected or retained pursuant to incidental or routine communications between DOH and qualified patients or providers. Do I need to introduce members, or
No, I don't
we
think
can just
so.
go ahead and
I think we
proceed?
can just go.
Okay.
You got quorum, right?
Yep, I've
Okay.
got quorum. So the recommendation on behalf of Consumer Protection is to pass with amendments, removing this SD1 amendment that requires a prescribing provider to conduct an initial visit in person and allow the initial visit to be via telehealth. The reason that we feel comfortable taking that particular one out is because in order to provide a prescription for a controlled substance, that has to be an in-person assessment. So there would have to be an in-person assessment at some point before medical aid in dying would be, prescription would be provided. So that's why the committee recommends that we don't need it as the initial visit, and that could be done via telehealth. I'm concerned particularly about access and in neighbor islands and in rural parts of Honolulu. And we will note in the committee report that providers across the state must complete in-person assessments prior to prescribing a controlled substance, which is already in the law, so the initial visit need not be in person. So the recommendation is to pass House Bill 1823 with amendments.
You guys decide what you want to do on the PAs. You can take that out.
No, I'm fine with
You'll
it.
leave them. Okay.
I'm fine with leaving
They just
the
have to be,
PAs.
they just have to be supervised.
Yeah,
Okay,
yeah.
that's fine. Okay.
That's in their scope of work.
Okay.
So any questions or comments? If not, Chair recommends we pass House Bill 1823, House Draft 2, Senate Draft 1 with amendments. And for CPN, Chair votes aye.
Chair votes aye, Vice Chair votes aye, Senator DeClerc.
Aye.
Senator Nishihara.
Aye.
Senator Riviere.
No.
Senator San Buenaventura.
Aye.
Senator Favela. Excuse, the recommendation is adopted.
Okay, for JDC members, same recommendation. Any questions or concerns? If not, Vice Chair.
Members passing with amendments, Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
No.
Senator Kim.
Reservations.
Senator Lee.
Aye.
Senator Favela is excused. Recommendation adopted.
Thank you. That brings us to the end of our agenda. We're adjourned.
Thank you. Okay, coming back out of recess on our 9:30 agenda. Members, were there any other questions on HB 1888? On electioneering communications for non-candidate committees? Okay, seeing that, we'll go on to the last item on this agenda. HB 1453 specifies that refusing to provide identifying information to a police officer when being detained for a traffic offense is a petty misdemeanor. Let's see. On 1453, James Talley for the Office of Public Defender. Good morning.
Hey, good morning, Chair, Vice Chair, members of the committee. I am James Talley with the Office of the Public Defender. We are opposed to this bill. What we're troubled is by the fact that a person that is stopped for a relatively minor offense, such as jaywalking, can end up in jail for up to 30 days, just because a police officer doesn't believe the person when he says who he says he is, or the person doesn't have an form of identification. Second, the measure, as we read it, essentially requires everyone to carry a form of identification. And as our written testimony indicates, many people do not carry identification at all times. And third, we do have a constitutional issue problem, as the statute, even statute currently, is unconstitutional on its face. It's vague on its face because it basically leaves too much discretion to the police officer to determine whether sufficient identification is established. I believe no one has challenged the current statutes because it's only a violation, and the cost of litigating on appeal is just too costly. But if we do criminalize it, I anticipate anyone that is charged with this offense, this statute will be subject to challenge. Otherwise, we'll stand on our written testimony, and I am available for any questions. Thank you very much.
Thank you. Next is Braden Ogata, Captain for Honolulu Police Department. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I am Captain Braden Ogata of the Honolulu Police Department, and I'm speaking in support of House Bill 1453 HD1 for reasons stated in my written testimony. Just as a summary, violating this section by refusing to provide information requires officers to issue a citation. However, issuing a citation is not possible if that person will not give you their name. This is a functionality issue which this bill will correct by offering a progression of options to include arresting the offender for a petty misdemeanor if necessary. Now, it has been brought up that this bill would adversely affect homeless individuals. While it is always important to consider potential disparate treatment, in my experience, officers often have a rapport or familiarity with homeless individuals in the area, and they are not who would be affected by this bill. This law becomes relevant when officers try to stop unfamiliar violators who are defiant, often argumentative, and sometimes educated on the law. In these cases, under the current law, in lieu of any other arrestable violation, the officer's only recourse would be to allow the violator to walk away without a citation. Again, this is solely an impracticality issue, which we're hoping to correct. I will be available for any questions, and I thank you for the opportunity to testify.
Thank you very much. Next, we have Carrie Ann Shirota, Policy Director for the ACLU of Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Carrie Ann Shirota on behalf of the ACLU of Hawaii. We oppose this measure, which would criminalize people for refusing to provide ID, identifying information to a police officer when detained for a traffic offense. We also want to reiterate that in Hawaii, a petty misdemeanor is punishable for up to 30 days in jail, as well as a fine of up to $1,000. On its face, this bill invites a legal challenge. The proposed measure is unconstitutionally vague and may be deemed a violation of the Due Process Clause of the 14th Amendment of both our U.S. Constitution and Article 1, Section 5 of the Hawaii Constitution. We also believe it raised concerns with our Fourth Amendment, which is the right to be able to not respond to questions by the police. Beyond the constitutional concerns about this bill, it is unnecessary and harmful. I have not heard any sort of justification in terms of measures, in terms of data, that this bill is required to address a systemic problem. And yet there is data to suggest that there are racial and wealth disparities already within our policing practices. And this will disparately impact houseless people, as well as people who are leaving our jails and prisons, many of whom leave without civil identification due to the state's failure to comply with Hawaii law. The fact that Hawaii Department of Public Safety is not complying with this specific law that's been on the books for 5 years, and yet people are leaving without IDs. And again, jaywalking, some other type of matter, they're questioned. Also, houseless people who may have their documents, whatever identifying documents, may be swept away by cities and counties in their houseless sweeps. So this would have a disparate impact. We also want to bring up the fact that this is just truly punitive. Would this enhance public safety by changing it from a citation to a petty misdemeanor? And as all of you are aware, our jails are severely overcrowded. If someone is arrested and then taken and detained, they may not have the money to post bail. And this continues our vicious cycle of passing laws that may, on its face, tough on crime, but does not enhance public safety. So for all these reasons, we ask that you defer this measure. Thank you so much.
Thank you very much. Next is Trisha Nakamatsu, Deputy Prosecuting Attorney for the City and County. Good morning.
Good morning. Good morning, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Department. Thanks for allowing us. Thank you, Chair, for allowing us to testify on this matter. We did submit late, but we wanted to point out that this is a very real problem. That, I mean, while not perhaps at the level of felonies or more egregious matters such as that, perhaps, it is a problem that officers on the street could be issuing a citation to a pedestrian or a bicyclist, and that person could simply refuse to provide their name or their address. We don't read, well, at that point, if the person were to refuse to provide it, this would allow, as written, currently allows the officer to issue a citation for an infraction, we believe. But if that infraction has no name, it's just written to John Doe or a fictitious name, then really there's no enforceability to it. And so you would have that, a loophole, essentially, if people were to know about this. We don't interpret the same way that the piece was indicating on page 2, line 19. We don't think that that creates a blanket requirement for everyone to have ID. It's only any identification. So that means if any is available. We do see that on page 3, lines 4 through 8, there is a requirement there if the officer has reasonable grounds to believe that the person is being deceptive or misleading. We can see how that language could benefit from some tweaking. Without doing further research, we could look into it, maybe something of reasonable suspicion or a more familiar term that has a more established standard. However, there is a standard clearly already in the statute. So it's not as though it's just a flat requirement. With regards to the penalties, this would basically allow the officer to take them in for booking if needed, or just tell them, I really don't want to arrest you. Please just tell me your name. And you can always limit the jail time if that's more appropriate.
Thank you very much. We have Also, Robert Cavacos for State of Hawaii Organization of Police Officers and Support, Cat Brady, Community Alliance and Prisons in Opposition, Director Butai for Department of Transportation and Support, Misha Williams with comments, and 1, 2, 3, 4 individuals in opposition. Members, any questions?
Question.
Senator Favela.
We're going to start with HPD.
Morning, sir.
Yeah, hi. So I heard you earlier said that most of the officers in their sector or the district kind of know the individuals that is houseless in the community. I just like know, even if they do give you their name and their address, this too will be a tool to, because they don't actually have an ID, give you guys another tool in arresting individuals that don't have an ID if you guys suspect that the person is not giving you the right information. Then there's another tool that you guys have that I've been seeing you guys do out there on the leeward side, is you guys take pictures of the individuals. So if I do give you a false name, you still have my identification and picture to go with whatever incident that the infraction had caused. I'm just worried that this is gonna clutter up the again the judicial system and our prison by having this infraction and then having them arrested and then infringing on our constitutional rights not to answer questions unless we're being detained or actually being arrested. So if we get a misdemeanor or crossing a sidewalk or whatever the infraction is, that shouldn't be a subject to arrest because we don't want to give you all our information or we don't have an ID on us. How is this going to help you guys really in the field when you guys have more than enough material to identify, especially like you said, most of the time you guys know the individuals within the community. So I just want to know, how is this going to enhance the serve and protect that you guys do out there?
Okay, thank you, Senator. First off, it wouldn't, when you're talking about people who we have information for, sir, that actually wouldn't really be the situation here that we would have to worry about. It's when they just outright won't tell you who they are, and they violated one portion of the 291C sections, and like common one is jaywalking, and they won't even give you their name. So the officers then are stuck. They cannot do anything with it if the person chooses to just walk away. And I got to tell you very straightforward, tell all the members of the committee, it's not the homeless individuals or houseless that we see this with. It's sometimes tourists, educated. I don't want to go into all the different groups that we observe with, but it's people who are more defiant, that are just not wanting to, give their name. And when that comes up, the officers are stuck. We cannot do anything. And basically we have to just allow them to walk away, and we cannot enforce the law as we're supposed to do, sir.
Thank you. Senator
I have a follow-up for Officer Ogata. So I can appreciate, this is the second time you said basically that, the constitutional concerns regarding the homeless population that have been brought up in the testimony by the public defenders and the ACLU are not your target in addressing this or in trying to change the statute. But you do see how statutorily we would, conceivably, if they are right, we would be allowing that type of activity to, we would be allowing the law enforcement to be able to engage in that type of activity. And so the prosecutors just said that they would be willing to potentially look at specific language in the statute to address your target objective while also continuing to provide some legal protection on that homeless side, which I can see in dealing with officers in our area, exactly what you're talking about. Is that something you would be open to?
Definitely, sir. And I would also say, Senator, it's important to know too that we definitely do not want to be arresting people for these types of things. It's a matter of function, because if we can explain to them that, just understand, if you choose not to give me your name, you may be arrested. Just by doing that alone, that solves a lot of problems and reduces conflict. It's actually a form of de-escalation. to be able to have a clear guidelines for all of our officers to follow. Also, I did want to note that we do also make every effort to use our databases, meaning looking up state ID. Maybe it's, because it's not a requirement to have the ID on you for, non-driving or non-moped or whatever, for bicycle and walking offenses. So that definitely is not at least the police intent at all. So we wouldn't have any issues with making sure that language is clear. We're solely here, and I'm actually reaching out to you because the police officers actually brought this up, and I'm the legislative liaison. So they're saying this is a problem that we cannot deal with properly. And I think that's basically why we're here. So anything, with the other concerns to make it better for all sides, that's completely understandable.
Okay, thank you.
Members, other questions? If not, I have a question for you, Captain. So right now, what is, if you're arrested for something, you still don't have to give your name, do you?
Well, you don't, sometimes people don't give their names, but they are brought in and they're fingerprinted. At that point, they're identified.
But even if they don't, you don't have a fingerprint for every person in the world.
Okay.
It's a question, really. I mean, if you have a prior, sure. And for other things, if you're a member of law enforcement or there's a whole list of things that you can be fingerprinted for, but not everybody is fingerprinted. In fact, I would say a minority of people are fingerprinted. So how does getting arrested, how does that change anything? Can't they still just say, I'm not going to give you my name?
Oh, I'm sorry, say that. I missed that. I'm sorry, Senator.
Can't they still just say, I'm not going to give you my name?
Yes, and I'm a little detached from the receiving desk, to be honest with you, Senator. That was a very early part of my career. So I may have to not mislead, I may have to follow up and see how they deal with that. But I know we do have methods to get through that process if by chance. I don't ever recall in my personal experience a situation where we couldn't identify the person, to be straightforward, sir.
So, but I guess the part I'm stumbling over is if you can identify them at the police station, why can't you identify them in the field?
Oh, we don't have the fingerprint option out in the field, sir. Not currently with our technology. So, and don't get me wrong, there are options with the computer. They will try to look up the people and will query officers if anyone knows, but a lot of times they're unfamiliar. They might be tourists. They're just people not from the area that we're familiar with. So we do make an effort to use the computer, but it isn't foolproof. And this is an important progression in that.
Okay.
Go ahead.
So the 291C infractions, which is the traffic code, those are not arrestable offenses?
No, only there's one for basically refusal to provide, with a lawful order or the direction, that's 291C-23, obedience to police officers, but generally they're fines. And this particular one is $122 fine right now.
Okay. All right. Thanks. Members, other questions? Senator Lee.
Thanks. Just one follow-up. Right now, the penalty for this is, I believe, a petty misdemeanor up to 30 days and some fine higher than a few $100s, I believe. Is that right?
Yes. Well, it's a fine right now. You're saying our current situation is $122 fine. If you're saying for the proposed bill, I'm sorry, is that what you're asking?
Yeah, for the proposed bill.
Yeah, so if it would be a petty misdemeanor, then it's up to 30 days. And sorry, I don't have my paper in front of me, but there's a potential fine that the court could put on.
Yeah. So I think to the vice chair's point about what is really necessary for this, I mean, 30 days seems somewhat excessive. I would imagine if you were actually going to arrest someone, let's say that there is a mechanism in place that you'd obviously be able to identify them much sooner than 30 days, I would imagine. So to be able to ensure some sort of protection or some sort of happy middle ground that you were talking about with reducing that down to something more appropriate for this particular purpose be something you're open to. Just, I mean, I don't know what that would be exactly, but moving it out of the petty misdemeanor statute.
Yes, well, as long as it's arrestable, because we have to be able to get the person into the station to use our available resources there to try and identify them. That's kind of at the crux of this. So yeah, anything, as far as the actual any potential jail time, that's not really, for me, that's not our interest on the police side too much.
Yeah, thanks. I'm just thinking of like, what is the lowest common denominator here that you can put in place that both allows you guys to identify who you need to identify without allowing a tool that can be used inappropriately should there be a whole bunch of other folks that want to do other things with it.
Understood, Senator.
Yeah, thank you. Thank you, Chair.
Thank you. Other questions?
Yeah, prosecuting attorney,
Yeah, Senator Favela, go ahead.
please.
Sorry, Senator, did you say prosecutor? It wasn't hard.
Yeah, so I just wanted
Okay.
to follow up of what the public defender said. So we understand it's supposed to be used for a traffic infraction. But again, a lot of our people that is or will be in this violation, let's say I'm in a car and I get pulled over in the car. I don't have my identification. I make some refusal. Being in the car, you already have license on the car, there's registration for the car, there's other identifications that the officer can identify on. But when the reason why this is very scary, and I'm saying this because I work closely and I love my law enforcement officers, and none of them in my community ever abused anything like this. But I'm afraid, and I'm being truthful, that if we give them this tool or this opportunity, we will have some of these, not in my district, but some of these officers will use this tool to further their engagement. And I don't want to use the word racism or stereotyping or profiling, but this is going to be a tool that's going to be getting some of these guys that would not and refuse arrested 30 days, misdemeanor or not, having a charge on them. Maybe they never ever got arrested before. And I know some of the guys who the officer is talking about, but what I'm afraid for the officer and even you from the prosecuting office, that this will be sooner or later abused. And that's the part that I'm very afraid of, because I have a lot of my family members in a community that being victimized by just being on the streets, and their stuff gets stolen, like the ID, birth certificate, social security card, or weather damage, or they came out of prison 3 months ago, no identification. So I'm afraid that that for them is going to be a revolving door. So that's the biggest fear that I have, that in the future, we cannot guarantee that we pass this bill, that it's not going to be abused. So is there anything else that you guys can help us with? Because this is a potential of incarcerating people. So that's the question.
I'm sorry to interrupt. We're running out of time. I think what I'm going to do is we will.
Oh, sorry, Chair.
Sorry. No, we have caucus in like 10 minutes. So I think what I'm going to do, members, is we will roll the continuation of this hearing and the votes on these two bills over to the same day that we were going to see. Is that too late? Is Wednesday too late for the JDC symbols? No, we got till Thursday. Okay. We'll go ahead and roll the decision making on the first bill, 1888, to Wednesday, April 6th at 9:30. We'll put it on the same agenda with the votes for the judges, and we'll continue this hearing on this bill, but there won't be any more testimony taken, but we'll have, if you can come back for that, we'll ask you more questions. Otherwise, we'll decision make at that point. So we'll just roll everything till Wednesday, April 6th at 9:30. Okay, so this the 9:30 agenda is recessed until next week. We do have a 10:35 vote on things going on right now. So let me go talk to the Attorney General for a second, and we'll be right back. Okay, a little late. This is the Judiciary Committee from Friday morning. We're going into our 10:35 agenda, which was decision making on Governor's Message 596, submitting for consideration confirmation to the Attorney General of the Department. Attorney General Holly Shikata for a term to expire on at noon on December 5, 2022. Okay, So having spent the last couple days going over the submissions that Mr. Hamagami and Ms. Shikata submitted to my office, I can't say is that that any of it was very flattering to the Department of the Attorney General. However, I will be recommending that we confirm Ms. Shikata. You have some pretty severe challenges in the department, I believe, and I hope you'll take this opportunity this next 8 months to try to address them and move the department in a positive direction, even though your term is not a full term. There's a lot of challenges, I think, internally, and of course, all the other work that you have to do as a department. So recommendation is to, let's see, this is to consent or conform. I can never remember what's it say. Advising consent. Okay. Any discussion? If not, Vice Chair for the vote.
Members voting on Governor's Message 596, the chair's recommendation is to advise and consent to the nomination. Chair Rhodes.
Aye.
Vice Chair goes reservations. Senator Ocasio.
Reservation.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Reservations.
Chair recommendation adopted.
Okay, thank you very much. We're adjourned. So your vote will be